The Office of Justice Programs of the U.S. Department of Justice and the Pretrial Justice Institute convened the National Symposium on Pretrial Justice in Washington, D.C., May 31st and June 1st of 2011. The symposium marked the 50th anniversary of American bail reform and of Attorney General Robert Kennedy's National Conference on Bail and Criminal Justice. The Honorable Eric Holder, Attorney General of the United States, and Timothy Murray, Executive Director of the Pretrial Justice Institute, laid down the challenges facing pretrial justice nearly 50 years after the bail reform movement began.
It is a privilege for me. It really is a privilege to join with top federal officials, members of the bench and the bar, federal, state, and local law enforcement and corrections officers, jail and prison administrators, victims, prosecutors, former defendants, and advocacy organizations as we examine, discuss, and ultimately work to improve the state of pretrial justice in America. Today, after decades of study, analysis, and cooperation, there's no doubt that compared to Attorney General Kennedy's time, current pretrial release and diversion programs are not only more effective, they are more just. And yet, serious problems as well as significant inefficiencies remain. Across the country, nearly 2/3 of all inmates who crowd our county jails at an annual cost of roughly $9 billion taxpayer dollars are defendants awaiting trial. 2/3 of all inmates are awaiting trial. Now, many of these individuals are nonviolent, non-felony offenders, charged with crimes ranging from petty theft to public drug use. And a disproportionate number of them are poor. Now, the reality is that it doesn't have to be this way. Almost all of these individuals can be released and supervised in their communities and allowed to pursue or maintain employment and participate in educational opportunities and their normal family lives without any risk of endangering their fellow citizens or fleeing from justice.
As we meet here today to mark almost 50 years of bail reform, we have much to celebrate. Yet we also must take this opportunity to confront the challenges to safe, effective, and fair pretrial justice as we figure out collaboratively how to make those elements a reality. Across this country, there are more people in jail this afternoon awaiting court action than for any other reason. Thousands upon thousands of these individuals now detained will actually be released once they're convicted. Thousands more will ultimately have their charges dismissed when reviewed by a prosecutor. All too often, our current system permits the unfettered release of dangerous defendants, while those who pose minimal, manageable risk are held in costly jail space. All too often, we see pretrial release decision-making built upon a one-dimensional model which neither supports the legislative presumption in favor of release, nor takes into account individual strengths and risks of each defendant. So here we are, 50 years after Bobby Kennedy convened the first national meeting on bail reform. Here we are, 50 years later, asking the same question those pioneers asked 50 years ago. Is this the best we can do? When cash-strapped local governments turn to us for guidance on how to use their expensive criminal justice assets, are we giving them the best we have? When victims simply look to us for informed, rational decisions that take into account appropriate consideration of their cares and concerns, Are we giving them the best we have to offer? When those arrested look at our justice systems and see, as John Goldkamp wrote many years ago, two classes of the accused, separated not by danger or risk, or even the certainty of conviction, but rather separated simply by their social and economic class. Do we tell them it's the way it is? It's the best we can do. The fact that you're here supports the notion that we can, in fact, do better. With the advantage of modernized bail laws in the majority of states, with the advantage of evidence-based practice to guide and inform our work, with the advantage of jurisdictions that have confronted these issues head-on and shown that safe, effective, and fair pretrial justice can be a reality. This time more than ever, is our turn to get it right.
The data. Criminologist Dr. James Austin presented data to provide context for the symposium's discussions.
The crime rate now in the country is what it was about in the mid-1960s in California, where I live part-time. It's where it was in 1958.
Notwithstanding the sharp decline in crime rates, Dr. Austin noted that jail admissions remain high.
12 to 13 million admissions into the system each year. It is where the punishment is being dealt. If you want to punish people and get a large number into that punishment thing, because that's what jails are designed to do, about a third of those 12 million are gone in the first 2 to 3 days. And this is what's important, I think, on pretrial release. If you don't get out of that jail system in 2 to 3 days, you're going to stay for a while. And you're probably going to stay in the neighborhood of, 4 to 6 weeks, 8 or 9 months, depending on what the case looks like. So if you don't get out there quickly, you're going to be staying. There is a change in who is in that jail at any given time. So this would be what we call a snapshot of the jail population, and 61% of the snapshot is pretrial. And that percentage seems to be moving. An increasing number of the jail population at a given day is going to be pretrial, and you're going to see that the vast majority of that 61% are pretrial felons. And there's been a big shift in financial versus non-financial releases. Non-financial releases are declining. Financial surety bond, cash bail is increasing. But what's real interesting to me, based on the BGS data, if you look at the felons that are brought into the jail, 76% are returned to the community, generally within a few months. And their disposition is going to be reinstatement on probation, credit time served for jail, dismissal of charges, but they're not going to state prison.
The need for individualized risks and the role played by pretrial services. Symposium speakers addressed the flaws in the pretrial release decision-making practices of many jurisdictions. In most communities, decisions regarding bail are made on the basis of the arrest charge, rather than on an assessment of danger to the community or failure to appear in court posed by the individual defendant.
The fact is, a sound pretrial infrastructure is not just a desirable goal. It's vital to the legitimate system of government and to safer communities. And we need to ensure that the decisions made during the pretrial stage are based not on intuition or custom or a fixed bond schedule, but on determinations of risk and safety that rely on data and individually based assessments. In other words, we need an evidence-based approach to pretrial justice that realizes the system's full potential.
Attorney General Holder re-emphasized this point and highlighted the role that pretrial services programs can play in assuring an evidence-based approach to pretrial release decision-making.
By competently assessing risk of release, weighing community safety alongside relevant court considerations, and engaging with pretrial service providers in private agencies, as well as in courts, probation departments, and sheriff's offices, we can design reforms to make the current system more equitable while balancing the concerns of judges, prosecutors, defendants, and advocacy organizations. We can help those serving on the bench make informed decisions that improve cost effectiveness and preserve safety needs as well as due process. And we can spark, as Robert Kennedy did, not only a vital discussion, but unprecedented progress.
Bail reform in the District of Columbia.
Throughout the United States, pretrial release reform has been highly successful in communities where it has been implemented.
The District of Columbia has taken the extraordinary step of eliminating money bail from the pretrial release decision-making process. Defendants are either held without bail under the detention provisions of the statute because they pose unmanageable risks, or they are released on non-financial conditions, individually tailored to match the risks that have been identified. The results have been very encouraging. 85% of defendants are released non-financially, and the remainder are held without bail. 88% of those released appear for all their court hearings, and 88% go through the pretrial period without being rearrested on new charges. Only 3% are rearrested on felony charges.
There are a wide range of different conditions that we can ask the court to implement to make sure that if somebody's released, they're not in our custody, but they're still not posing a danger. In our view, it's not only the correct way to look at this issue, it's also a necessity, because I don't understand, in fact, we were just talking about this, how some of these other jurisdictions have the bed space in the jails to hold as many people as they do. It's incredibly expensive for the state to have that cost. And so if you can accomplish the same two primary goals, safety and somebody returning to court, without holding them, without incurring that expense, it definitely is the way to go.
D.C. Police Chief Kathy Lanier spoke of the importance of the D.C. Pretrial Services Agency in making this approach to pretrial release decision-making, which does not rely at all on money, work.
It's kind of genetically ingrained in police officers to do a couple of things. One is criticize everybody else in the justice system. Right? There's some cops here, they know what I'm talking about. Two is to have the mentality that hold everybody pre-trial. They're all guilty if we arrested them. So I want to kind of dispel that myth a little bit, and I think that we've evolved somewhat, and I think part of what has caused that evolution for me, 21 years working here in D.C., is having the privilege of working with the Pretrial Service Agency. And so what's been so important for us over the past 5 years is that we've reduced violent crime and homicide here in Washington last year to the lowest level we've seen of homicide since 1963. Having been the murder capital of the world when I started, that's a big accomplishment. And I credit a lot of that to the work that's been done by the Pretrial Services Agency.
Susan Schaefer, director of the D.C. Pretrial Services Agency, listed 5 elements that have led to D.C.'s success in getting very high release rates and outcome rates without the use of money bail.
The first is what I've explained, the accurate information that we can provide to the court about defendant risk. The second is a quick charging decision by the prosecutor. The third is the presence of defense counsel at first appearance. The fourth is the appropriate and transparent judicial responses to individual risk factors. And those factors are provided in the pretrial services report, and the court makes its decision based on a consideration of those factors and any other information that's brought to the court's attention by the prosecutor and the defense attorney. It's all transparent, it's in the open, it's not hidden behind money. And finally, we have a commitment to tracking results. Our police chief, our U.S. attorney, our public defender, everybody is committed to tracking results, and we do that together through our Criminal Justice Coordinating Council. Again, I think a very important way that the various entities within a jurisdiction can come together and look at what they're doing, look at what's working, look at what needs to be changed, look at what they need to do better, and we do that quite well.
This final point was echoed by Chief Lanier.
you know, having a system like pretrial services here in Washington is really going to be contingent upon the commitment of everybody in the justice agency. You can't just create it and let it go on its own. Everybody has to collaborate, and they have to be committed to it, and you have to have good, committed people that are working in the system.
Reducing the reliance on money bail. Research continues to demonstrate that it is possible to reduce the reliance on money bail without endangering public safety. Dr. Marie Van Nostrand describes some of her recent research findings on what individualized risk assessments can do, especially when coupled with release conditions designed to meet the risks posed by each defendant.
And what we found really was that preliminary support for the risk principle, which is that the moderate and higher risk defendants who were required to participate in these alternatives to detention did better than similarly situated, meaning similar risk defendants did, who did not participate in these alternatives. And similarly, low-risk defendants who were required to participate in these programs did worse than low-risk defendants who were not required to participate. And so we're beginning to have some support for this concept of the risk principle. But to me, what's most interesting about these research findings is that it's consistent with the law, right? The law tells us that a person has the right to release on the least restrictive terms and conditions, and the research tells us that that's going to produce the best outcomes.
Much of the discussion at the symposium focused on why reducing a reliance on money bail in pretrial release decision-making is important. Assistant Attorney General Lori Robinson identified the fiscal reasons.
Data from our Bureau of Justice Statistics show that more people are in our nation's jails because, as Tim pointed out, they're unable to post bond, even a small bond, than for any other reason. And in spite of declining crime rates, the rate of pretrial detention has actually increased over the last few decades. One huge consequence is that pretrial detention comes at enormous fiscal costs to already strapped local governments. And it has profound social costs to our communities. Of course, it doesn't have to be this way because research suggests that many of those who are detained could be safely released.
Temple University professor John Goldkamp described the confounding effects of money bail on developing an empirical basis for pretrial release decision-making.
So it's hard to evaluate a judge based on the results of the judge's decisions when using cash bail as the primary vehicle, you're throwing the decision up in the air. First, we need to move state systems to direct decision-making. That means skip the dollar game, make direct decisions with these mechanisms for feedback and review. And tricky as that is, and we heard yesterday about, oh, the resources involved. Well, that means you don't have a hearing now when pretrial release is determined. If you have a hearing now, then we can take a few more steps and have some direct detention release decision-making and assign conditions of release and skip over the side effects of the cash-based detention.
Recently, Jefferson County, Colorado has implemented changes that will reduce their reliance on money bail.
But after 4 years of some pretty significant debates, just recently, we made some dramatic changes to our system as a system. In particular, we eliminated our commercial money bail bond schedule. We now have included instead a process document. It's not a money bail bond schedule anymore, but it's a process document that more reflects the national standards and our own philosophy about bail. We have weekend advisements now. We have defendant representation at bail now. We have much less reliance on secured bonds and commercial sureties. We have more informed decisions about defendant risk and the response to that risk, with an emphasis on pretrial release, on non-financial conditions. So what have we learned from all this? And this will be my summary points. One particular thing that we learned was that our data show that money does nothing to further the purpose of bail. By that I mean court appearance and public safety. money, in fact, hinders the purpose of bail. Now, money does one very good thing, and if you want this thing, you should have a lot of money in your system, and that keeps people in jail, and our data show that as well.
Commitment to pretrial justice, a system-wide approach. Pretrial justice encompasses much more than having a high-functioning pretrial services program. It also involves the commitment of key stakeholders. Here's Philadelphia District Attorney Seth Williams talking about the importance of early review of cases by prosecutors.
And one of the first changes I made was I had to change our charging unit, the way in which we assess cases and charge people. We have to charge the right people with only the right crimes, and then make sure that bail is set appropriately. In the past in Philadelphia, the standard wasn't probable cause or proof beyond a reasonable doubt. The standard of charging was, well, I wasn't there. We'll let a judge figure it out. And we then abdicated our responsibility to the courts. We only put people in charging that had been problem people who had demonstrated bad judgment. So I learned from Bonnie DeMantis that we have to put people that have demonstrated good judgment, people that have a lot of experience as trial attorneys, put them in the charging unit. So I went from having 5 people with bad judgment to 15 outstanding prosecutors in our charging unit to make sure that we get it right from the very beginning. But we've made a lot of dramatic changes. We've reduced the prison population from about 10,000 to about 7,400. And again, it's not my goal to have just fewer people in prison. I want to have the right people in prison. But we've reduced the number of people that are there as a result of pretrial detention.
The same week as the symposium, the American Council of Chief Defenders of the National Legal Aid and Defenders Association issued a policy statement calling on criminal justice stakeholders to make a new commitment to help assure fair and effective pretrial release decision-making. Ed Monahan, chair of the council, discussed the challenges public defenders face in assuring pretrial justice, beginning with the initial appearance of the defendant in court.
The problem is, will there be a public defender in the courtroom to make any argument? And if that public defender is there, will they have less than 400 or 500 or 600 cases to be able to make an argument that is based on individual information competently obtained? That's the question.
The symposium also touched on the importance of educating victims about the pretrial justice process.
It makes sense that victims would be included in the process at minimum, that education about what is transpiring would inform everyone, because apart from the assumption that they're the biggest stakeholder, the fact is they are the biggest stakeholder, are they not?
Commitment to pretrial justice, national support. Tim Murray of the Pretrial Justice Institute discusses the policy statements and resolutions of national entities calling for the reform of pretrial justice.
We see key stakeholder input on this issue of pretrial justice. As has been cited by Lori and others, the National Association of Counties in its national charter, with all 3,000 of its member counties ratifying, called for the assessment of all arrestees, a report provided to the court for use in making pretrial release decisions, and said conditions should be made on the least restrictive possible circumstances. American Probation and Parole, in their public statement, the role of pretrial services is to enhance both the short-term and long-term public safety while providing access to treatment. Association of Prosecuting Attorneys recognizes that the value of accurate and reliable pretrial information is ultimately for the enhancement of public safety. And this year, the International Association of Chiefs of Police identified the law enforcement's leadership role in ensuring that pretrial release decisions are based upon individual risk and not bond schedules merely associated with charge titles. The American Jail Association recognizes the high functioning value of pretrial services, as does the American Bar Association, which, as has been announced earlier, has launched a national initiative that includes pretrial justice as a money-saving, public safety-enhancing strategy. And just this past week, the American Council of Chief Defenders released a resolution calling on defenders to examine pretrial release practices within their own jurisdictions and to work with all stakeholders to improve criminal justice and pretrial practice.
James Birch, Acting Director of the Bureau of Justice Assistance, describes some of the federal efforts that have been underway to improve pretrial justice.
We think together, the Department of Justice and the Pretrial Justice Institute, or PJI, have had a remarkable partnership and a remarkable set of initiatives to move the field forward, particularly in this area of pretrial justice and pretrial justice decision-making, all in an effort to ensure fair administration of justice, which is a core part of our missions that we both share. And so certainly we found ourselves with the perfect partner to pursue pretrial justice enhancement and improvement. We do this because we know that for our justice system to be fair, to be safe, and to be effective, that we must have pretrial services in place, and they must be evidence-based or evidence-driven.
Deputy Attorney General James Cole also spoke of the desire for the expansion of pretrial services programs to enhance evidence-based decision-making.
Lori and her staff at OJP are providing critical support to state and local jurisdictions to bolster their pretrial systems. And I know you've heard about some of those efforts here at the symposium, and many of you, in fact, are directly involved and are on the cutting edge of innovative pretrial practices. We're seeing a growing number of these programs throughout the country, but we'd like to see more. We need to make these innovative practices the rule and no longer the exception.
Enhancing pretrial justice during a fiscal crisis. Many speakers noted that implementing enhancements to the current system of pretrial justice may seem to have a low priority in the current fiscal environment. However, such enhancements may be the appropriate response to the budget challenges we face by having an overall reduction in jail costs, the county's most expensive resource.
The issue that I believe can motivate legislators from across the political spectrum to re-examine our pretrial practices is the budget, the expenditures. From the state to the national level, governments across our nation are facing budget shortfalls. Legislators of all stripes are looking for places to cut spending without harming worthy programs. The amount of money that governments spend on detaining offenders is breathtaking. It costs nearly $24,000 per year to house an inmate in a state jail. The cost of incarcerating an individual in the federal system is even higher, nearly $26,000 a year. As budgets are scrutinized for cost savings, all of us should push our elected officials to make the connection between reforming pretrial services and practices on the one hand and saving taxpayers' money on the other.
But I also understand it requires some upfront money. Okay, I understand that there is a short-term investment for a long-term financial gain. And people are going to need to be aware of that, and they're going to need to make that investment. But overall, when you look at what it costs to supervise effectively an individual outside of the court system as opposed to housing them in court, the numbers are pale in comparison.
One of the interesting analogs, not totally analogous, is the effort that Pew has made in the last several years through its public performance project. I know some of you do work for that, as does Vera and CSG, and certainly Lori works with them. But Pew decided years ago that they were going to take on the issue of mass imprisonment and measure itself on the reduction in money that states spend in prisons. And you wouldn't have necessarily thought a few years ago that there would be governors clamoring, dying to be a Pew state, right? Please let me be a Pew state so I can cut my correction expenditures and reinvest them in other things that make sense, or that Texas would pass a massive piece of prison reform legislation, that Michigan would close 13 prisons. There is a moment here for the insertion of a larger political and fiscal strategy that I think can help drive this, and will obviously be local at the end of the day. There's not going to be one big one-size-fits-all strategy, but there has to be a national, well-funded, public and private, effort to sort of enhance what you do, and you shouldn't feel the onus on growing that yourselves. And I think it's possible, and there is a moment here, and we should take advantage of it. Thank you.
But it's not just about the costs, the issues of equal justice and fairness. There are implications for enhancing pretrial justice beyond just the cost savings and public safety. Professor John Goldkamp discussed racial disparities he found in his research on pretrial release decision-making.
We addressed the question of disparity. And by the way, once you solve the intellectual question of what similarly situated means at bail, you'll discover that disparity is more pronounced at the pretrial stage than it ever was at the sentencing stage, and that sparked years of sentencing reform.
I think it takes the goodwill of the smart, talented people in this room to make it a priority. I was struck when Tim was speaking about how, a few years ago we would have thought mental health wasn't important, a few years ago, and I thought, it was actually a cultural change. I think race is always uncomfortable for people to think about, and anytime you point out a racial disparity, immediately someone thinks, well, you're calling me a racist. Sometimes that's true, but it is. And sometimes it's not that. It is we're making decisions that are not informed decisions, that are not evidence-based decisions, and they have an impact that we don't anticipate. Sometimes you can see it, and sometimes you have no idea that if I just simply took prior arrests for nonviolent offenses out of the equation, that would drastically reduce the racial impact. If I take marital status or college education out of the equation in terms of whether I release or detain, that would change the calculus. But the numbers are pretty clear in jurisdictions across the country, and it just takes an effort on the part of the administrators to simply say, I'm going to make this a priority, and we're not going to perpetuate these disparities as we move forward with the reform.
Access to justice is our responsibility. Dealing with that issue at the pretrial level of justice is critical to the future of this country.
Judge Truman Morrison urged participants not to forget the right of everyone coming through the criminal justice system to be treated with fairness.
But we need to remember that every time a person is unnecessarily held in a jail cell until their trial, that's an immense human tragedy for that person, their family, and it radiates out into the community. And we should never apologize for, when we're talking about justice policy, for talking about fairness.
Historic event issues call to action. Several speakers noted the historic importance of this symposium and asked attendees to use it as a call to action.
And what an exciting time, possibly an historic time, for our profession and for the subject of pretrial justice.
I have to say this really has been a fantastic constellation of people that have come together to talk about a very critical issue. It was critical in 1964, and it's critical today.
This meeting, it's really interesting to me, after hearing all that I've heard today, that it took 50 years for us to reconvene a symposium, a national symposium on an issue which is so critical, so important to the fair administration of justice.
And so the work that this conference will do, the recommendations, the ideas, the creative solutions that will emerge from this conference may well find their way to my desk, to my work, as the Justice Department persuades Congress to continue to work to improve the administration of justice and to give the Justice Department the tools that it needs to assist criminal justice systems around the country.
With federal, state, and municipal resources in high demand and in short supply, the simple truth is that government can't solve these problems alone. We need to engage key partners and innovators across the country to guide our efforts, to bring an expanded network of stakeholders to the table, and to push for responsible reform. So, to be blunt, we need your expertise, we need your ideas, and we need your help. Our discussions must be grounded in rational and transparent risk assessments, built on evidence-based tools and predicated on the presumption of innocence, but ever mindful of the need to keep our neighborhoods safe. Now, each of you can play a key role in this effort. You can help us find ways to support the growth of pretrial service agencies and diversion programs in the more than 300 jurisdictions where they already exist, and encourage their creation where they do not. You can fight to ensure that for every defendant who enters the system, our judges have access to the best information possible, along with a range of supervision and service options, as well as sound guidelines to inform their decisions. And you can broaden our engagement with other experts on the ground, raising the profile of this work and igniting, once again, a movement for meaningful change. We still have much more to do. This symposium marks an important step forward in what I know and what I pledge will be an ongoing conversation about how we can achieve safe and fair pretrial release and diversion practices in our communities, and in so doing, make our justice system both more effective and more efficient.
Because the time for you guys to listen to speeches, mercifully, is over. It is, however, time for you to go out and start giving speeches. The time for you to sit and watch presentations is done. It is time for you to include pretrial justice in every presentation that's focused on criminal justice reform. It's out of the closet. It's not a secret. It's not a pretty picture. It needs all the light and air we can give it. And finally, the time of pointing to little tiny PJI and saying, we love them, they're the only shop in America that is concerned with pretrial justice, is over, damn it. Because now you're involved. Thank God you're involved. We need you so much.
More information about the National Symposium and pretrial justice may be found on this website.